Welcome to the Municipal Clerks Workshop on Event Venue Alcohol Beverage Law Implementation, presented by the Division of Alcohol Beverages. I'm Ann DeGarmo, Supervisor of the Education and Outreach Unit here at DAB. I am re-recording this presentation from the live version to correct some inaccuracies in the original presentation and provide additional information. Just a quick disclaimer, this presentation is intended to promote a general understanding of laws governing alcohol beverage regulation in Wisconsin. This presentation does not provide administrative or enforcement decisions on specific facts or circumstances. For assistance in applying the concepts in this presentation to a set of facts, consult an attorney or reach out to the division. Quickly, we'll run through what we are going to be talking about in this presentation. First, we'll discuss what the law is going to be on January 1st, 2026. Then we will discuss some paths for event venue businesses to comply with the new laws. We'll discuss the application forms and the process that municipal clerks or the division and event venue businesses will need to follow in order to apply for those paths to compliance. We'll talk about the early stages of implementation and what that will look like. We'll talk about an additional option for nonprofit organizations that could be considered. We're going to talk about above-quota licenses and the nuance that's required prior to issuing such a license. And finally, we'll discuss the some scenarios to lock in your understanding of the new laws about whether or not a particular type of business or a particular event needs an alcohol beverage license. First and foremost, I want to talk about the fact that this presentation is future-oriented. All of the laws that are impacting event venues go into effect on January 1st, 2026. If you need assistance applying the laws to events or businesses that are happening right now, at the time of this recording, it's November 2025 or into December 2025. The laws are different than what we're going to talk about, so please be sure to reach out to the division or consult the resources that are available to you, like Publication 309. First, we're going to go back to basics and talk through about when an alcohol beverage retail license is required. There are two instances separate from one another when an alcohol beverage license is required. The first is when alcohol beverage consumption occurs in a public place or when any sale of alcohol beverages takes place. Keep in mind that this test is two separate parts. If alcohol beverage consumption occurs in a public place, a license is required. Or if a sale of alcohol beverages takes place, that license is also required. The laws relating to sales of alcohol beverages have been on the books for many, many years. Sale or sell is a broad term that includes any shift, scheme, device, or transaction to obtain alcohol beverages. It's a very big concept and is intended really to ensure that people cannot skirt the law by getting creative with their solutions to give people alcohol beverages in exchange for some other good, service, or financial transaction. A few examples. If admission is charged for an event where alcohol beverages are served, that's considered a sale of alcohol beverages and requires a license. If someone is buying a cup or making a donation when entering a venue, that is also a sale of alcohol beverages and requires a license. And finally, a free alcoholic drink with a food or merchandise purchase or any other type of purchase is also considered a sale under state law and requires an alcohol beverage license in order to engage in those sales. The point of these examples is purely to just illustrate how broad the concept of a sale is for Wisconsin alcohol law, and ensure that you understand that if a sale occurs, a license is required, full stop. Like I said, this hasn't changed with the no sale event venue or event venue changes that are going into effect in January. This is a tale as old as time, but we wanted to just bring this to light so that it's top of mind as you're considering the scenarios that we have later on in the presentation. Next, we're going to talk about the portion of the law that has actually changed with 2023 Act 73 that's going into effect on January 1st. It's that first bullet point that I showed you on the earlier slide. We're talking about alcohol beverage consumption in a public place. Section 125.091 is amended by Wisconsin Act 73, and it simply states that a public place is a broad, undefined term in Wisconsin alcohol beverage law, and it's a concept that has been on the books for many years. So the spirit of this provision hasn't changed at all. It has just gotten more specific. The concept is just that alcohol beverage consumption in a public place is prohibited without the appropriate license or permit. To further plain language this, it essentially means you can't drink in public without a license. If a place is considered a public place, if it's in public, alcohol beverage consumption, just alcohol beverage consumption, also requires the appropriate license or permit in order to engage. So the portion of the law that I have highlighted on the slide right now hasn't changed a ton with the changes in Act 73. What I'm showing you in the highlighted portions now is the portion of the law that actually has changed. And this section specifies if the general rule is that there's no drinking in public, the highlighted portion of the law and the addition to the law states that these specific venues, an event venue business that holds itself out to the public for events or social gatherings is definitely a public place and requires an alcohol beverage license or permit in order to engage in alcohol beverage consumption at that business. And again, these are very broad terms. It is any sort of business that holds itself out to the public for an event or social gathering. I will say event or social gathering is highlighted and is said 3 separate times within the statute. So please keep that in mind when you're talking about event venue businesses. It is for events or social gatherings, not mere tenant-landlord sort of relationships or other reasons why an event venue may be rented to the public. Also not new to the law as if you've done alcohol beverage law for any period of time, you'll know that for every rule, there are several exceptions. So in the next slide, we are going to talk about the general exceptions to Wisconsin alcohol beverage law. So these are the exceptions in Chapter 125.09 to the public place law. Essentially, these exceptions mean if the general rule is that you can't drink in public, if there is an exemption to that rule, it means that these places are not considered a public place, and it is okay for alcohol beverage to consumption to occur in these places without an alcohol beverage license or permit. There are several specific ones. There are a couple of new additions, and there are some items that have been on the books for a very long time, so I won't belabor this point too much, but with that, we'll get into it. The first provision that is an exemption to the public place law are rooms in hotel, motels, or bed and breakfast that are used for overnight accommodations. Again, just reiterating, the whole hotel, the whole motel is not exempt from public place laws, just the guest rooms. So a person will always be able to carry a 6-pack of beer or a bottle of wine in the guest room, but if the hotel the lobby is open to the public, and anyone can walk in and, for example, choose to rent a room in that space, a license or permit is still required in order to engage in sales or consumption in those common areas of the hotel. The guest rooms, always exempt. To that extent as well, vacation rental property or other short-term lodging that's used for overnight accommodations is also considered exempt under state law from alcohol beverage consumption rules. So you will always be able to carry in alcohol beverages, a bottle of wine to your Airbnb or wherever you're staying for overnight accommodations. However, there is a very important caveat to vacation rental property or short-term lodging. In order for that property to be exempt under the law, it must be furnished with sufficient beds for all adult guests to sleep. So please keep that in mind as you're considering about vacation rental property or short-term lodging. Again, along the same vein, we have campsites at licensed campgrounds. Again, this is not about common areas of that campground. This is about the specific individual campsites. Campers will be able to bring a bottle of wine or a 6-pack of beer to their campsite, but if there are any common areas, that is not exempt and is considered a public place and requires a license. And certainly if the campground is interested in selling alcohol beverages themselves, that activity requires a license as well. Our new additions are related to tailgating. So a parking lot, driveway, or yard where vehicles may be parked on the same day as a professional or collegiate sporting event or other ticketed event open to the public is not considered a public place for purposes of consumption. So if someone is tailgating in a parking lot near American Family Field or near Lambeau, that parking lot is not considered a public place and does not require an alcohol beverage license or permit in order to allow consumption. However, if there are sales happening in these places, people are purchasing beer or intoxicating liquor, any of those things in these places, that exemption no longer applies. And also keep in mind that it's not just that this is property near Lambeau Field or near American Family Field. It has to be this is only exempt property when there is an event happening that is open to the public or a sporting event that's going on. So if there isn't a Brewer game or there isn't a Packer game happening or a concert at one of those places, it's no longer considered a public place. This isn't a blanket exemption. It's for a specific period and snapshot in time. To that end, we have our local professional baseball park or football stadium districts if the property is used in connection with an event. For those of you that are near American Family Field or Lambeau Field, you know whether or not you or the businesses that are nearby are a part of the stadium or the professional baseball park district. Those are specific geographical areas that would be exempt from consumption rules. And again, it would be in a context of something like tailgating or some other sort of event-related activity in which that property is considered exempt. A few more exemptions that have been on the books for a very long time. First is municipal and county parks and buildings. If you have a town hall, a community center, a library, municipal and county property is exempt from public place requirements, which means that if you have ordinances governing rentals of your park shelters for private events or your community centers or even the rooms within your library, your municipality or the county in which your municipality is can create ordinances that govern the use of those properties and allow alcohol beverage consumption and carry-ins to take place. I will say, again, this is an important distinction, is that if, for example, your Lions Club rents your municipal park pavilion in order to do a fundraiser and is selling alcohol beverage in that context, they will need to pull an alcohol beverage license in order to do that. You are not exempt for sales purposes, but you are exempt for consumption purposes. It's a good practice, and the division has been advising municipalities if they have property like this where they want to allow alcohol beverage consumption, just be sure that you have some sort of use agreement or ordinance on the books governing the use of that property. Oh. There are two more items that I wanted to talk about on the exemptions page. or a couple more items actually. One is school buildings. Alcohol beverage consumption may occur in school buildings or in campuses of private colleges, as defined in state statute for events sponsored by the private college. Again, this is not for sales. This is only for consumption. So please keep that in mind as you're considering these options. Further, we have churches, State Fair Park, and clubs. Again, all of this is about consumption. If any of these locations engage in sales of alcohol beverages at all, they are no longer exempt from public place requirements because they are making sales of alcohol beverages, and that separately requires a license. If you have questions about these, we're going to revisit this concept at the end of the presentation as we walk through a bunch of different scenarios. So hopefully that will give you a better sense of how to apply these concepts to any circumstances that occur in your community that you might need to determine if a license is required. A couple of takeaways. The changes to public place law that are being implemented on January 1st, 2026 mean that any space or area that is ever held out to the public for rent for purposes of an event or social gathering is considered a public place and requires an alcohol beverage license or permit to allow consumption to take place. Put very plainly, drinking in public has always been prohibited. The change to the law states that any event space that is held out to the public for events or social gatherings is now considered drinking in public and requires a license or permit in order to do so. And in this context, it also doesn't matter if the event or social gathering that's happening if that is a specific place where the drinking is occurring, or if that specific event is paying to use that venue. It is if that venue is ever held out to the public for an event or social gathering for rent, that is considered a public place, full stop. And then also, just to reiterate, any sale of alcohol beverages has always required a license or permit. And it's a tough concept to understand, but again, remember that both of these tests are separate, and essentially every event in every place has to meet both. If there's a sale of alcohol beverages that's occurring, do not pass go, do not collect $200. That's considered a sale of alcohol beverages and requires a license or permit. And then the second test is we determine whether or not alcohol beverage consumption is occurring in a public place. And again, the consideration for event space that's held out to the public is a pretty broadly defined. So there are going to be a lot of businesses and things that fall into that category now. Now we'll talk about the different paths to compliance for event venue businesses to fall in line and become compliant with the law effective January 1st, 2026. We have two options. The first is a no-sale event venue permit issued by the Division of Alcohol Beverages, or a municipal retail license issued by a Wisconsin municipality. First up is a no-sale event venue permit. There are some authorizations and allowed activities under a no-sale event venue permit that we need to discuss. The first is that renters of the no-sale event venue property can carry in beer and or wine to serve to guests without charge. Without charge is going to be a common theme that you hear within this presentation about no-sale event venue permits. It is in the name that this is an area where consumption of alcohol beverages is allowed, but sales of alcohol beverages are pretty strictly limited. There is one specific example in which sales can occur on a property that has a no-sale event venue permit, but for the most part, this is a strictly prohibited no-sale situation. So renters can carry in beer and or wine. Guests of the renter can carry in beer or wine. to consume without charge on these areas. And the exemption to my general statement about no sales occurring is that the renter, if qualified, may hold a temporary Class B license to make sales of beer or wine. This is when we're talking about picnic licenses, qualifying organizations. Those folks will still be able to pull a temporary retail license in order to make sales on a property that holds a no sale event venue permit. There are some restrictions that a business should be mindful of when they're considering this option. In terms of timing and the ability to do these events, it is quite limited. This permit only authorizes 6 events per calendar year and 1 per month. There are no distilled spirits able to be consumed or possessed on a property that holds a no sale event venue permit. This is a strictly beer and wine permit only. And again, no sales of alcohol beverages unless it's authorized under a temporary retail license. And again, because there are no sales, it means that there can be no charges for admission to events on this property. Because again, that would be considered a sale under Wisconsin alcohol beverage law and would require the appropriate license or permit in order to engage in those sales. And then finally, any event that has 20 or more people as guests are required to have licensed operators supervise the service of alcohol beverages on these premises for public safety reasons, and just to ensure that all appropriate alcohol beverage laws are followed. The next path we're going to discuss is regarding municipal retail licenses for these types of event venue businesses. There are 3 different options and a couple of different combinations of alcohol beverage licenses that an event venue business could pursue. The first is one we know and love, a Class B beer license. Class B licenses generally authorize on and off-premises sales. You'll see that there's a state-imposed fee range. Municipalities set these fees within the range set by state law in their municipal ordinances. So in order to determine how much you should be charging, you should look to your own ordinances ultimately. And a feature of a Class B beer license is that it is not limited by a state imposed. These are not subject to quota. A municipality may issue as many of these as they find appropriate for their community. The next type of license we have is a Class B liquor license. These are what folks will call a full bar. And allow for sales of all intoxicating liquor, which includes hard cider, wine, and distilled spirits. As I said earlier, Class B licenses authorize both on and off premises sales. And we'll talk more about the fee ranges and the different subtypes of Class B liquor licenses there are in just a second. These are the licenses that are limited by the state imposed quota, and these are the only licenses that are limited by the state imposed quota. Finally, we have a Class C wine license. This is a wine only license, and this license authorizes only on-premises sales. Again, we have the state imposed fee range, and these licenses are not limited by state imposed quota. The acceptable license combinations that we have here are both Class B licenses to create what some municipalities call a Class B combo license, which is a beer and a liquor license. And actually, both of those always have to be combined. You cannot issue a standalone intoxicating liquor license. A Class B intoxicating liquor license, it always must be issued in conjunction with a Class B beer license. Or a municipality could issue a Class B beer and a Class C wine license for the same premises. That is also an acceptable license combination and could be really appealing to event venue businesses because neither of those licenses are limited by quota. It gives them some just additional flexibility, and it's a license type that is available to them as soon as they can apply and get through the municipal process. Now we'll talk about the different types of Class B liquor licenses. There are 3 different types of Class B liquor licenses that we're going to discuss today. The first is a regular Class B liquor license. There is no initial issuance fee, only an annual license fee that is set in state law, or the range that a municipality may charge for the annual license fee is set in state law at $50 to $500. These licenses may transfer from person to person under limited circumstances, and they also may transfer from one premises to another within the same municipality, also known as a place-to-place transfer. The next type of license is a reserve license. Reserve licenses carry an initial issuance fee of at least $10,000, again specified in municipal ordinance, plus an annual license fee that is also set in municipal ordinance within the range that I have in the chart set by the state. Reserve licenses may be transferred under limited circumstances person to person, but they may not be transferred from place to place within the same municipality. Finally, we have above-quota licenses. Above-quota licenses are unique in that state law specifies that the initial issuance fee and the annual license fee for these are set in municipal ordinance, and there's really no other guidance provided by the state. So an above-quota license may carry an initial issuance fee, much like a reserve license that's different than the annual license fee, but it doesn't have to. And then again, there is no state imposed fee range. These licenses may be transferred from person to person in limited circumstances, but cannot be transferred from place to place within the same municipality. Generally, above-quota licenses are licenses that may be issued by a municipality who has reached their municipal quota for regular and reserve licenses. We're going to talk very specifically about how to calculate a municipal quota, and you'll learn that the regular and the regular license plus reserve license equals your municipal quota. Once you have met the number of licenses that you are allowed to issue under state law, that's when a municipality may be eligible to issue above-quota licenses. Above-quota licenses are issued specifically to certain types of businesses. They include restaurants with an interior permanent seating capacity of at least 300, some types of performing arts centers, hotels with large amounts of guest rooms and banquet space, and also qualifying event venues. So these are for limited circumstances, very specific types of businesses, and are essentially, think of them as exceptions to the municipal quota law, limited exceptions. So we'll talk a little bit more about above quota licenses shortly as well. Next, we get into quotas. So as we discussed, state law restricts the number of Class B liquor licenses each municipality may issue. Each municipality maintains its own quota. DAB does not maintain historical records of Class B liquor license quotas. We don't have the paperwork. We don't have the numbers. This is something that is entirely municipally administered. And as we discussed earlier, regular Class B licenses and reserved Class B licenses ultimately make up a municipal quota. A regular Class B license is the number of licenses granted or issued in good faith and in force on December 1st, 1997. A reserve license is an additional license that a municipality has gained due to population growth, annexation, or any sort of license transfer over the course of time. So essentially, your municipal quota is the number of regular Class B liquor licenses plus the number of reserve Class B liquor licenses that a municipality is authorized to issue. How do I calculate it? First, you're going to need to identify the number of licenses issued in good faith on December 1st, 1997. In Publication 309, we have Appendix C, which is a reproduction of the original worksheet that was provided to municipalities by the League of Wisconsin Municipalities in order to determine the number of licenses. So you'll be able to see this. You can go through your municipal records to determine where that paperwork might be. Again, it was about what was issued in December 1st, 1997, so you can look for records that were created around that time, and you'll be able to hopefully find this worksheet. Then you'll need to determine the number of reserve licenses that you've earned due to population growth, annexation, or license transfers. There are a couple of different data sources that you can look to if you, for whatever reason, can't find the worksheet that was completed in 1997. You can look for population numbers to the DOA, Department of Administration Demographic Services Center. That's the state agency in Wisconsin that's responsible for keeping track of municipal population. So you'll be able to see how your population has grown or changed over the course of time and if that has yielded any additional liquor licenses. You can also look for local newspapers. Through local newspapers to find publications for license application notices. Wisconsin law requires applications to be published in the local newspaper. So that is a really great source to determine if you need to back out and find the number of licenses that were issued in good faith on December 1st, 1997. You can turn to local newspapers to look for that. That's a good resource in absence that worksheet. Then finally, you can look to your governing body minutes and agendas. Wisconsin law requires municipal governing bodies to make determinations to grant or not grant a liquor license. So meeting minutes and agendas are a good place to look. Hopefully that gives you enough resources to calculate your quota to determine whether or not you have licenses available. If you have questions or would like to speak with somebody about calculating your license quota, you can reach out to the division and we will help you the best we can. Alternatively, if your municipality is a member of the League of Wisconsin Municipalities or the Wisconsin Towns Association, those are also great resources for you. Ultimately, if you need legal assistance specific to your municipality on your quota, it would be advisable for you to reach out to your municipal attorney to help you as well. Next, we will discuss application forms and processes for event venue businesses to come into compliance with the law. The first option we discussed for compliance is a no-sale event venue permit. So to that effect, the no-sale event venue permit application is Form AB 353. It is posted online and businesses may apply at any time. Permits will not be issued until the first day of 2026. And they will be granted a no-sale event venue permit from the Division of Alcohol Beverages to display on the property. Further, businesses will be able to access their permit when it's granted through their My Tax account. And this is a pretty straightforward process. Businesses will just need to find this form, fill it out, and get it to the Division of Alcohol Beverages. And then we will consider these and get them granted in the order that complete applications are received. Next is for the standard municipal retail license application form. If the business is applying for a Class B beer and a Class C combo license, or your municipality is not at quota and has a Class B liquor license available, a business can apply for a Class B beer and a Class B liquor license combination. In this context, a business can apply at any time for these combination of licenses. Applications are submitted to clerks, to all of you in the audience. And just please be mindful of the 15-day waiting period. That 15 days is an amount of time that must pass before the governing body can act on a license, either grant or deny. It's certainly that they cannot grant a license prior to the 15 days. So if there are any time issues, Please be mindful and work with the business to determine the appropriate timing to be sure that that application can be considered timely. AB 200, AB 100, and AB 101 are the forms that a business taking this path will need. Finally, we will go through the qualifying event venue certification application and the above quota Class B liquor license process. The forms for this path for municipal purposes are the same. You'll need AB 200, AB 100, and AB 101 completed for the business. And then for the portion, the qualifying event venue certification, businesses will use AB 510, which is the qualifying event venue certification application, and AB 511 is the qualifying event venue certification municipal declaration. Event venues need to submit AB 510 to the Division of Alcohol Beverages as soon as possible and before March 2nd, 2026. Keep in mind that qualifying event venue certification is for a limited time only. Businesses must essentially tell the division that this is the path they're considering and that their municipality is at quota no later than March 2nd. If they're not entirely sure or they're not confident that they want to take this path, but they want to be sure that it is a path that's open to them, they can submit AB 510 to the division in any state of completion before March 2nd, 2026, and it will essentially buy them a little bit of time to work with us to determine the right path forward and whether or not we're going to ultimately fully process their application. The next information that the division will need is AB 511. This document is filled out by the municipal clerk or other designated official on behalf of the event venue. Once that form is filled out, it should be submitted to the division. Either the municipality can submit it to us or the business that is seeking qualifying event venue certification can submit it to us in addition with their AB 510. Also of note, municipalities may begin the alcohol beverage license application as soon as possible, and it is recommended that you begin the process as soon as possible. You cannot issue an above quota license to a business that does not have their qualifying event venue certification in hand, but there is a provision that states that a governing body may grant a Class B license contingent on certain circumstances. And one of them can be that they're going to grant a Class B liquor license contingent on DAB certification as a qualifying event venue. You will know that a business is certified from the division because they will be able to provide you a letter the division is going to issue certification letters to approved qualifying event venues, certainly via US mail. So they'll have a document from the division specifically stating that they are certified when the time comes. So as I reiterate, just to summarize this slide, because this process is a bit convoluted, AB 510 and AB 511 are filled out and submitted to the Division of Alcohol Beverages. AB 510 is filled out by the business. AB 511 is filled out by the municipal clerk. Both of those forms need to make it back to the Division of Alcohol Beverages in order for the application to be considered complete for a qualifying event venue certification application. Municipalities do not need to wait until certification is in hand from the division in order to move on the next steps of approval for a liquor license. A qualifying event venue certification is not a guarantee or even consideration about whether or not a business is qualified to hold a liquor license. That's the reason why we are encouraging municipalities to begin the application process for the liquor license as soon as possible. You need to run background checks. You need to do all of your zoning checks, public health requirements, anything that is required of alcohol beverage businesses in your community will now be required of this business as well. So it would be constructive for you to begin that process sooner rather than later. Once an event venue is certified by the division, they will receive a letter that they will be able to share with the municipality when that certification is granted. And finally, consider that a governing body is able to conditionally grant a Class B license contingent on DAB certification per state statute. If you have questions about this process or you're still confused, we will have more guidance coming out on this in the coming weeks, so please stay tuned for that. And if you need additional assistance determining the best course of action for you and for a business in your community, please reach out to the Division of Alcohol Beverages. So a few notes when we're considering these alcohol beverage businesses or these event venue businesses. The first is we've received questions from clerks about who is supposed to decide what is the best authorization for a business to come into compliance. And ultimately, the answer is that it's the business. The business knows their own business model, they understand their own needs, and this is a decision that ultimately the business needs to make. Certainly, they have to pick a path. Compliance is required in this instance in order to remain in good standing with Wisconsin state law, but ultimately it's not clerks or municipalities that make a decision about what the path is for a business. The business has to make that choice themselves. There are some resources on the division's landing page in order for them to make choices. The event venue resources box is in the top right-hand corner of the DAB landing page. So that is a great place to point businesses who you understand will need to come into compliance. We certainly have a bit of a timing issue. Businesses have to be compliant with the law on January 1st, but generally they're not going to be able to get their authorizations until January 2nd at the earliest. That's true. The way that the law was written means that all of the laws go into effect at the same time, requiring compliance, but also not creating the event venue permits or the above-quota license until January 1st. So there's a little bit of a order of operations problem that we have here. We at DAB understand that this is going to be a bit of a conundrum to get businesses in compliance when they need to be in compliance on January 1st, but they're not going to be able to get authorizations until January 2nd. Our focus is going to be processing applications, ensuring that businesses know that the law has changed and that they need to come into compliance, and really we'll be getting the word out in the early stages. But certainly that doesn't absolve people from not following the law, but it does mean that there will be some time where our emphasis will be on education and outreach. And we would love clerks to help us get the word out. You're closer to folks in your communities, which is why we put together this presentation. So your assistance in getting this information out is also really critical. We have some event venues that are run by nonprofit organizations in communities across Wisconsin. Do they have other options that for-profit businesses don't have? The answer is maybe. Temporary alcohol beverage licenses may be a reasonable path, but there are some limitations that should be considered here. The first is that just because an organization is a nonprofit organization doesn't mean they are qualified to hold a temporary alcohol beverage license. The first job of a municipality in this instance is to determine if they are considered a qualified organization. And if that's the case, then they may be a good temporary alcohol beverage licenses may be a good option for them. Then temporary alcohol beverage licenses are for events of limited duration. If there is an event venue business that is using alcohol beverage licenses every single weekend in order to engage in this, they're not going to be able to keep alcohol beverages on the premises between events. They're not going to be able to carry over alcohol beverages from one authorized issuance of the license to another, from one weekend to another. And there are going to be other limitations that need to be considered. I would say that the more events that an organization holds each year, the more difficult and complicated this path is for the organization to do legally. And then finally worth considering is that only 2 Class B wine licenses may be issued to a qualifying organization per calendar year. So in some instances that may be limiting for an organization, that they may want to consider getting a regular full Class B liquor license or a Class B, Class C combo. Next, we'll talk a little bit more about above-quota licenses. There's a lot to know about them. Lots to know. Above-quota licenses, again, are for specific types of businesses that meet specific criteria in statute, like a qualifying event venue, that exist in municipalities that have reached quota. If your municipality is not at quota, you are not eligible to issue any above-quota licenses. Note that above-quota licenses do not transfer from place to place within a municipality. That's a limitation of them. Because they are inherently above quota, they are not in addition to a municipal quota. And there is one nuance about the qualifying event venue above quotas that you should understand and that businesses should understand when they're trying to determine what the appropriate path is. A qualifying event venue above quota license may transfer to a new owner of the same business if they agree to operate it as a venue. There is no DAB recertification required. They won't have to come back to the Division of Alcohol Beverages, but that venue, essentially, the transfer is only good for as long as that business is operated as a qualifying event venue. So if there's going to be changes to the business model, or they're going to half the amount of events or something that are going on there, there's going to be a bigger question about whether or not that license can transfer. At this point, we're just working on issuing the licenses in the first go around. This will certainly be an issue as time goes on, and municipalities are welcome to use the division as a resource if they encounter a circumstance where a qualifying event venue that is issued an above quota license is going to sell, and we will help you through that process. Okay. We've reached the scenario portion of the presentation. We're going to talk through whether or not an alcohol beverage license or permit is required to allow alcohol beverage consumption in the following scenarios. In order for this to work, you have to assume that alcohol beverage consumption is occurring in every scenario. So the first scenario is that Anne is hosting a bridal shower for her sister-in-law at her primary residence. Guests are invited friends and family. This is not a public place. My house is not available for just anyone to walk in, and in this instance, only invited guests will attend this event. The next circumstance is also at my house. I have a very active social life. I am hosting a house party fundraiser at my primary residence for a local political candidate, and the fundraiser is listed publicly on Facebook. A donation is suggested but not required. In this case, an authorization is required. Note the similarity is that this is at my house, but someone's house is not always a not public place, and it also can very much be a public place. So in this case, authorization is required, and this is both a public place, alcohol beverage consumption in a public place, and also constitutes a sale of alcohol beverages. If alcohol beverages are being served to folks who donate to this local political candidate, that's considered a sale and requires a license on its own. Next, we have a chamber of commerce that is hosting business after 5 for chamber members at a bank that rents their meeting room to the public for events or meetings after business hours. This is a tricky one. This is considered a public place because the bank is renting their meeting room to the public for events or social gatherings. It doesn't matter if the Chamber of Commerce has paid to rent that space. It doesn't matter if it's in sort of a separate area. If that bank is held out to the public for rent after business hours, it is considered a public place. In this case, it's a pretty straightforward situation. The chamber is eligible specifically by state statute to get temporary Class B licenses, so that can be the straightforward solution for this type of event. Next, we have Tyler hosting a birthday party for his cousin at a City of Fitchburg Park shelter. Guests are invited friends and family. In this instance, this is not a public place because alcohol beverage consumption is exempt. In this instance, it's city property. Tyler is not making any sales at his birthday party for his cousin, and the city has ordinances and requirements on the books governing carry-ins of alcohol beverages at their park shelters. We wish them a great birthday party. Next, we have the Acme nonprofit. They're holding their board of directors meeting at the Acme nonprofit office after their normal business hours. Generally, board meetings are not for nonprofits. They're very much invite only. Not anyone can attend these sorts of events. It's closed business activity. And to that effect, this is not considered a public place. And if the Acme nonprofit would like to consume perhaps a bottle of wine while they're conducting their board of directors meeting, they're welcome to do that in this instance. Next, Meg's Book Club is renting space at a local bookshop after normal business hours. This is a very straightforward situation. The book club is an event or social gathering. The book club is renting space from the bookshop. The bookshop is required to have an alcohol beverage license or permit in order for consumption to take place at this location. Next, we have a couple of vacation home instances. Caitlin is renting Anne's vacation home from a listing on a short-term lodging app. No more than 10 adult guests can book at a time because there is space for 10 adult guests to sleep. In this case, alcohol beverage can happen at Anne's vacation home because there is sufficient space for all adult guests to sleep. Anne's vacation home is ever rented to more adults than have sufficient place to sleep. So Anne does not need to acquire an alcohol beverage license or permit in order to allow consumption at this vacation home. Next, Meg is renting Anne's family vacation home on a short-term lodging app for a micro wedding with 50 expected guests. The vacation home, pretty big. It sleeps 25 adults. This is considered a public place because there is not sufficient space for all adult guests to sleep. There's 50 expected guests, but the vacation home itself only sleeps 25. In this case, Anne's vacation home is required to hold an alcohol beverage license or permit in order to allow alcohol beverage consumption to happen at events like these. This is the contact information for the Division of Alcohol Beverages. If you have questions or need clarification or need help finding resources, please don't hesitate to contact us. Thank you so much to all the municipal clerks who were able to attend this presentation live. We know you're very busy people, and we're very grateful for the partnership that we have in sharing the responsibility of regulating alcohol beverages in Wisconsin. And thank you for all you do. Again, if you have questions, please don't hesitate to reach out. Thank you so much for listening. Thank you so much for watching live. Thank you so much for tuning in at the end here and watching the recording. And we hope that this has been a useful and helpful resource for you. Thank you.